This talk is about a number of recent changes in immigration law which have arisen and give rise to important considerations as to the future conduct of immigration and asylum claims. My name is Toby Davey. I'm a barrister and part-time immigration judge, having been a legal chairman in the IAT for many years, and I still continue both as an immigration judge and doing what are called first stage reconsiderations. The views I express today are entirely my own and are not those of my professional colleagues, and the views I express on a number of matters are essentially intended to be helpful, and I hope, having dealt with all the various matters that I will address today, you will be something the wiser. I won't be citing from text at any length. That is in the accompanying material, along with the multiple choice questions. My start is the recent decision of the House of Lords in Huang and Kajiri, 2007, UKHL 11, which has taken onwards the decision of the Court of Appeal and essentially reversed what in many respects we thought was a reasonably clear-cut and operationally effective way to address Article 8 claims. The House of Lords opinion is given as an opinion of the entire House, and the fact of the matter is it is set in the context of an old claim touched by Section 65 of the 1999 Immigration and Asylum Act, although it is hard to see why the very same principles spoken to would not equally apply to appeals under Section 82 of the 2002 Act, although it seems that it may be appeals which fall to be considered under Section 85, subsection 5, may be an example of looking at matters away from the usual picture of the date of decision by the tribunal. The historical position in relation to the assessment of Article 8 ECHR claims arose from the decision of the House of Lords in Rasgar in 2004. And in the principled opinion of the court, Lord Bingham set out 5 questions that appeared likely to him to need to be answered. And those were, in short, first, will the proposed removal involve an interference by a public authority with the exercise of an appellant's right to respect for his private or family protected life rights? And if so, would the interference be of such seriousness or gravity as to give rise to an interference and potentially engage Article 8? Thirdly, is the interference in accordance with the law? Fourthly, if so, is it justified by reference to the requirements of a democratic society, the maintenance of law and order, and so forth? And finally, if all those matters are engaged, is the interference proportionate to the legitimate public ends sought to be achieved? Those questions raise inevitably a mixed question about on whom does the burden of proof and what is the standard of proof that needs to establish these relevant elements. The position was discussed quite recently in the Court of Appeal in a case called Mukaka, which identified that arguments about burden of proof shouldn't be taken too far, and that the structure in two parts of Article 8 necessarily then required, first of all, the identification of a protected life right and whether or not there was a serious interference with it, and if there was such serious interference, then the justification through the need of immigration control, public policy and the like, the lawfulness of the decision obviously, and then finally to the question of proportionality.